silence has been deafening from the district attorney, whose office prosecuted the murder case. Nobody has seen the DA.
Now, we did, of course, reach out to the district attorney's office for their response to this protest, but have not yet heard back.
Not yet heard back.
The DA's office has not responded to the filings from today.
His office did not return our phone calls.
After 2 days of calls, emails, in-person visits, we received this statement from a spokesperson of Norfolk District Attorney Michael Morrissey. Quote, "There will be no comment about Commonwealth versus Karen Reed."
He is inaccessible and invisible. And as I've said before, this is never going to lead to good government. So the fact that he's essentially in hiding right now is completely unacceptable.
In a Massachusetts county where power often operates behind closed doors, a district attorney's silence may speak louder than his words.
Only one candidate has all it takes to be Norfolk County District Attorney. Michael Morrissey, a leading trial attorney for 25 years. He's written the tough laws to take criminals off our streets. The only one with 3 decades of experience working with community groups to prevent crime. And the only one with a legal management experience to run the county's prosecution team. Michael Morrissey, most qualified to be Norfolk County District Attorney.
The discovery of Boston police officer John O'Keefe's body in the snow-covered yard of 34 Fairview Road in Canton sent shockwaves through the tight-knit community. Soon after, his girlfriend, Karen Reed, found herself at the center of a murder investigation. For nearly 15 years, Michael Morrissey commanded the spotlight. Every case was an opportunity for Morrissey to step before the cameras and address the public. In other tragedies, Morrissey appeared ready to answer for his office. But not here. Not for Officer John O'Keefe. The man who had never met a camera he didn't like suddenly developed an aversion to the spotlight. But why? Why did this DA, who had stood before cameras for far less, choose to vanish behind press releases?
The district attorney is responsible for any kind of death in the county. So if an individual is found unattended, let's say someone is found in a parking lot someplace, then the state police would work with the Walpole police and they would determine whether or not it's an accident or it's a homicide. So the troopers actually are trained and they rely on crime scene services and other investigative means. And they tell me I'm being filmed today. So everybody has a cell phone and most of you take pictures. And so there's a lot of work that they, when they go to a scene, they look around for cameras. People have Ring doorbells.
The neighbor across the street, Detective Lieutenant Kelleher, had a Ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it.
And so we have a lot of evidence gathering, plus the old-fashioned methods of talking to people, fingerprints, blood spatter that you would expect. So in the case of a death, then we would have control, meaning the district attorney and the state police are my designee.
A police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside. And one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating.
Before Karen Reed's first trial even began, District Attorney Michael Morrissey took an unusual step. He released a pre-recorded video statement addressing the public directly. This statement was made before a jury heard a single shred of evidence. It felt less like a measured update and more like a declaration of guilt to me. The presumption of innocence, a cornerstone of our justice system, seemed notably absent for the defendant, Karen Reed. This initial statement set a perplexing tone. It felt less like a neutral pursuit of justice and more like a DA already deeply invested in a singular outcome and aggressively dismissive of any alternative. A detachment from the very public he serves, choosing a monologue over dialogue.
But the district attorney says now that witnesses are being harassed, he had to do something he's never been pushed to do before.
This will be the first statement of its kind.
The first statement of its kind. Morrissey immediately establishes that this is unprecedented, but why? What makes this case different from every other high-profile case he's handled?
In my dozen years as Norfolk District Attorney, the harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died.
So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house.
Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home.
Just look at Mr. Whiffen's data, Ian Whiffen. John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen, himself conceded that he has reasonable doubts about the accuracy of John's location data. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation, this is science, and it's irrefutable. It tells us that he was not laying outside in the cold, he was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours. Never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage.
11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one.
Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it.
Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home.
And the homicides we have are generally people who know each other, domestics, roommates, fights and quarrels. Not too many random acts of violence.
Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them.
And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Celebrite at 2:27 a.m. A Google search that read, "Hoslong to die in cold." It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
The Commonwealth's own medical examiner, Dr. Scorti-Bello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. Their own expert said there is no evidence of a collision, no evidence of an impact. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch.
Notice the language. Absolutely baseless, outrage, decent person. This is not the measured tone of a prosecutor presenting facts. This is the emotional language of someone under siege. His tone was not that of a man with answers, but of someone condemning questions. No mention of motive, no timeline, just condemnation for anyone who dared to ask. Public scrutiny was dismissed as internet lies and defense theories as outrageous. But the cracks showed.
The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
What District Attorney Michael Morrissey does is when a case comes across his desk that involves police officers, he sweeps it under the rug. Look at the Sandra Birchmore case.
Be a hero.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident.
Hours into this investigation, there will be some serious charges brought on the girl.
Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road.
Michael Proctor had done zero investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe.
In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so.
Motive includes anything from financial gain to could just be revenge, right?
Yes.
Could be a lover's quarrel, correct?
Yes.
Or it could be someone who's interested in someone romantically, correct?
Could be an argument inside of a vehicle.
Yeah, which is the conclusion you jumped to 17 hours into your investigation, right?
Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
You didn't mention a thing about your relationship with Julie Albert, Chris Albert, or Colin Albert in any report that you ever drafted in this case, did you?
I did not.
Not one word, correct?
No, sir.
Your sister's literally explaining that your family friends are suspects or possible suspects in a murder investigation that you're in charge of.
And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias, bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another.
Morrissey's office then forced to send out letters to 13 defense attorneys, informing them that Proctor had been involved in their investigations as well.
DA Morrissey's publication prior to the trial of a video in which he publicly vouched for the credibility of his police investigators, including now disgraced Trooper Michael Proctor, violated the Massachusetts Rules of Professional Conduct for prosecutors. This is unconscionable behavior for a district attorney. DA Morrissey knew or should have known of Trooper Michael Proctor's unethical and biased behavior prior to the first trial, and he failed to take appropriate remedial action to prevent Proctor's conduct from jeopardizing the O'Keefe prosecution and other criminal investigations like the murder of Anna Walsh in Cohasset.
They are examples of cases where there are clear problems with a lack of integrity and objectivity.
Today, former Massachusetts State Police trooper and Karen Reed case investigator Michael Proctor trying to get his job back.
He remains terminated at this
state penitentiary, and I came dressed as Proctor's cellmate because I feel what he did, he needs to go to prison.
Be a hero.
DA Morrissey has been in office since 2010, with his last election in 2022. His term is 4 years.
And today, Massachusetts State Police confirming Trooper David DeCicco was transferred from the Norfolk DA's office to the Holden Barracks back in January. The news comes as Sergeant Yuri Buchanan, one of the lead investigators in the Karen Reed case, has been transferred out of the Norfolk County District Attorney's office.
It is not a demotion because he's allowed to retain his rank. However, the change of assignment is absolutely a disciplinary action on behalf of the department against Sergeant Buchanan.
The investigation was conducted with honor and integrity.
The changes and reassignments within state police.
We will always search for ways to do better, to enhance our operations.
Come as the department is initiating a new excellence initiative to regain public trust following the Karen Reed case.
Now the trial is over, myself and our team have taken the information, and we are in the process of reviewing that information.
After both trials, the story did not fade. Lead investigator Proctor was fired. Key prosecutors and officers reassigned, placed on leave, or quietly retired. What began as a quest for justice now ends in a county demanding reform, and a DA's legacy unraveling before his eyes.
This should be seen for what it is, and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now.
Be a hero.
Adam Lally led the prosecution in Karen Reed's first trial, which ultimately ended in a mistrial. When your prosecutor can't get a conviction in the biggest case of his career, what do? If you're Michael Morrissey, you reach deep into the taxpayers' wallets. A price tag never publicly justified. Each increase, another amendment, signed off without comment. The message to the public? Our own prosecutors can't handle this case.
More than $500,000. That is how much taxpayers in Norfolk County are forking over to pay the special prosecutor in the Karen Reed murder retrial. The exact tally tonight, $566,000. The Norfolk DA made waves when he tapped Brennan as the special prosecutor for the second trial. At the time of the announcement, the contract was capped at $75,000, but along the way, there were multiple amendments to that agreement, and the taxpayer costs continued to climb. Once the trial got going, invoices show Brennan was consistently billing 12-hour days. So let's take a look at the math. From the time jury selection began in April to the time the verdict came down in June, Brennan billed 678 hours at a rate of $250 per hour. So the total for his work during the trial was $169,500. And so remember, that's just the trial.
To me, it didn't make a great deal of fiscal sense, and it's cost the taxpayers a huge amount of money. And I don't see the wisdom.
The district attorney's $14 million budget after salaries leaves only $2.7 million for all other operational expenses, including rent, utilities, equipment for 144 full-time employees, and direct case expenses. The district attorney has spent more than 1/3 of his entire annual operating budget for the special prosecutor and expert witnesses on the retrial alone. Rather than reassessing the evidence after the first trial and seeking a more pragmatic outcome in line with the evidence that would free up resources for other cases, DA Morrissey doubled and tripled down on using every resource possible to prove he was right rather than seeking justice. Charging someone without a good faith basis to believe the Commonwealth can meet the high standard of proof beyond a reasonable doubt is simply unethical. I've not spoken to a single current or former prosecutor, not one of my former colleagues, who believed the evidence supported this charge.
His lack of transparency has completely undermined the community's trust.
That the general lack of objectivity and integrity in the investigative process in Norfolk County has led to essentially an erosion of the public trust and confidence in that office.
And I always tell people it's not about convicting someone, it's about getting the right answer.
Do better. Do better, sir. You are in the job of seeking justice. You're not in the job of winning cases. And that's what it seemed like he was doing. Not seemed like, that's all he was doing. And that's what Hank Brennan was doing. And that's what Laura McLaughlin was doing, who was writing all the papers, the abusive process, trying to keep all of our witnesses out of the courtroom. Literally, they spent hundreds and hundreds of hours filing motions, trying to keep our witnesses away from the jurors. Ultimately, we were able to overcome it, but it was not easy.
Her defense team is looking for new information from the Norfolk County DA. They're asking a judge to compel Michael Morrissey to hand over any texts or emails related to the case from his personal devices. In the motion filed today, the defense argues recent reports and evidence from a documentary suggest he used his personal email to communicate with Stoughton District Court personnel and judges. And because the case is ongoing, Morrissey's spokesperson declined to comment.
Aaron Reed's defense includes this email that District Attorney Michael Morrissey sent last fall. Now, this is an email that was sent from the DA's personal iCloud account to court staff in Stoughton. He asked the staff there to find an insider in the courthouse who had been leaking information about the Reed case to the blogger known as Turtle Boy. Now, the defense says the DA's email was improper because it was done through back channels. And so now the defense wants to see any other emails or text messages that the DA might have sent related to Reed.
As a public official, all of the district attorney's work-related communications are subject to the Public Records Law, which grants citizens the right to access information about how their government works. The Public Records Law is a critical component of government accountability. To ensure that records are complete and accessible to the Public Records Law forbids anyone from unlawfully keeping public records in his possession. So sending work-related emails and text messages on a personal device is a crime, and it's punishable by up to 1 year in the House of Correction. The district attorney should immediately comply with all court orders to disclose such records, and he should promptly disclose all non-exempt records that have been properly requested under the Public Records Law.
Citizens turn to their police department for their immediate safety, but they turn to the court process for lasting justice. I've assembled a very talented pool of attorneys and invested in them, getting them the specialized training and education they need to deal with complex and sometimes difficult cases. I have implemented a conviction integrity committee to look at our cases even after they have been resolved. Every attorney in my office knows that I measure our success not by the number of convictions we secure, but by getting the right answer, wherever justice falls.
I think the worst thing about this case and what the district attorney's office did is that it told the family of John O'Keefe that they could expect a murder conviction. Giving them false hope may put them through this experience that is emotionally devastating.
This was the most staggering result. Only 4% of those people answered that Morrissey deserves to be reelected.
And these were by far the worst numbers I had ever seen for any elected official I've ever polled.
District Attorney Morrissey's conduct can only be explained by incompetence or ego. Neither have any place in a district attorney's office. It's time for Morrissey to go.
He's up for re-election, and if he goes unopposed this time, shame on us.
To go. He needs to go.
We need justice. We got to find out the truth. What is he hiding?
There's obviously corruption going on in his county.
Be a hero.
We need to get out there and meet with residents and meet with community leaders and listen.
There has to be a clear message that no one is above the law, no matter who you are, no matter what your relationships are. We should be a model for justice. Norfolk County deserves better.
After 2 trials, countless hours of testimony, and millions of taxpayer dollars, 12 jurors rendered their verdict. Not guilty of murder, not guilty of manslaughter. And Michael Morrissey's response? The jury has spoken. 4 words. After 2 years of prosecution, 2 trials, and a case that divided Massachusetts, the district attorney had 4 words. The calls for resignation grow louder. But the real tragedy isn't the end of one man's career. It's the damage done to public trust in the justice system. Critical questions remain unanswered. The families of John O'Keefe and Sandra Birchmore deserve better. The taxpayers of Norfolk County deserve better. And the citizens who depend on prosecutorial integrity deserve better. Michael Morrissey built his career on the pursuit of justice, but in the end, justice may be pursuing him. In trying to protect his reputation, he destroyed it. In trying to avoid accountability, he ensured it. And in the legacy of Michael Morrissey, one truth haunts the halls. Justice demands not just a verdict, but accountability.
Let your voice be heard, not in whispers, but in truth. That justice cannot be bent, and that it will not be buried.